Okay, guys. So I think I have given you 10 minutes to read this. Now, Vidya Shankarji, you have raised your hand. Is there a question? Hello. Okay. So can anybody, Satish, what did you understand from the mood problem? Satish Kumar ji, Muthu Gandhi ji, I think
Yes,
he
ma'am.
wants to say something. Yes. Have you been able to go through it?
Yes, ma'am.
Okay. Any challenges and anything that you would understand?
Yes, ma'am. Ma'am, already the man is already married and also divorce problem in the court, and then married the girl. The name is I think Ritika, and also one fire accident for in that house. But this is an accident or like an incident. I don't know, ma'am, but a little bit confusion in that area. But the marriage is Hindu Marriage Act is under the Hindu Marriage Act. Already one person is divorce not giving to the person. That another marriage is, I think, offense, ma'am.
Okay.
Ma'am,
Ma'am, one more question, ma'am.
Yeah.
This is a accident or incident, ma'am?
What do you think?
I think this is an incident. I think, ma'am.
What is the question that is there in the last that has been mentioned? There are two sections that have been mentioned of IPC.
Yes, ma'am.
One is 498A and one is 307.
Yes, ma'am. 498 is convict the complaint, ma'am.
It's cruelty, right? 498A.
Yes, ma'am.
For cruelty, they have raised that section of IPC.
Okay, ma'am.
It's about it's your this thing. Yes, cruelty. Husband and wife subjecting to cruelty, right?
Yes, ma'am.
Marital. Okay. And the second question was on 307 of the IPC.
Yeah, 307 is an attempt to murder, madam.
Yes, great. Okay, so 307 and 498A. These are the two questions in appeal.
Yes, madam, but actually the drafter's note itself, it is mentioned there is no valid marriage. Participant should not.
Yes, okay, okay, great. So Satish is on the right track.
Yeah.
Right, okay. So, is there anybody else who would like to give me a gist of the facts?
actually, Siddharth would have to save Ritisha only, ma'am. So why he has poured kerosene to her?
Hmm.
So it comes under attempt to murder only, right, ma'am?
It depends what can be proved. Are the facts saying that it is possible to prove it?
So actually, he poured kerosene to Ritisha, right, ma'am? So it comes under an attempt of murder only, now. Whether he knows or not, whether the gas stove is there began there, he says that he don't know whether the gas stove is began there.
Okay, what if you look at the fifth para and read it again? On 5th of February, at around 2 a.m., a call was received at Shivaji Nagar police station stating that a woman with 75% burn injuries was brought to their hospital.
Yes, ma'am.
The police rushed to the hospital where the victim was identified as Rishika. Post regaining consciousness after a week, she gave a statement to the police. According to her, on that fateful night, Siddharth returned home from a party. visibly inebriated is he was drunk, right?
Drunk. Yes.
Upon unlocking the door, he saw Rishika standing near the stove, right?
Yes, ma'am.
Holding a can of blue colored liquid. He immediately realized that the liquid was kerosene and he rushed towards her,
Okay.
fuming with rage. He called her crazy and said that she had ruined all the fun in his life. He attempted to kill her by pouring kerosene on her, exclaiming that if she was so firm on ending her life, he
Yes,
would
ma'am.
make things easier for her. Immediately after Siddharth threw kerosene on her, she was soon engulfed in flame as her dress caught fire from the stove right behind her. Right?
Yes,
Now, guys,
yes, ma'am.
he poured kerosene. Okay.
Yes, ma'am.
Did he light the fire?
So it comes under.
So the point here is that these are the kind of loopholes. Why we read this problem right now is for you to understand that when you start reading a moot proposition that is given to you, no final verdict is true, which means it could be murder, it could not be murder, it could be attempt to murder, it could be attempt to suicide, it could be cruelty, it could be any of these things depending on which side of the case you are arguing from, what facts are you using correctly, how are you using those facts from the propositions, from the prosecution side or from the defense side, whichever, depending completely on which side moot memorial you're making, you're going to read the problems just as, right? So moot court is not this moot problem, this case that would have been given to you or any such cases that are given in moot problems are not essentially real cases that are brought to you, right? So there is no client, right? So do not get entangled in the spirit of getting justice, right? Because the moment you do that, what happens is that you get biased. You should have a very neutral viewpoint while you're reading the moot proposition, right? So, and we will do this thrice because, okay, because you are very new to law, my suggestion is, and I have mentored about 5 to 7 teams till now who have gone to different moot courts of national and international stature and have won something and come back. But the only thing is, everyone is in a rush initially, and I know when you start mooting and you're given a moot proposition, or you know that there's a competition 3 months, 4 months down the line, and you have to submit your moot memorial in like 2 months time, or you do not have much time, what students do is that they rush through the facts so badly that they miss out on essential things and essential arguments that they could have made based on the facts itself. So my suggestion, this is the methodology in which you should read a moot problem. You will give it a neutral reading once. Then you would, one reading like a newspaper, first reading is a newspaper like reading, right? Like you're reading the newspaper, you'll read the moot proposition. Second reading is a neutral reading. You are not biased. You do not have to think, oh, poor thing, this woman, Rishika, she got burned and the husband is so bad, or the guy is so bad, or whatever. You have to be very neutral. You have to think that nobody is a culprit. Until it is proven in the court, nobody is a culprit, right? You cannot call them convicts. They are just accused. Unless they are proven guilty, they cannot be adduced as criminals, right? So you have to give that neutral viewpoint to your head and start reading the moot problem again and make it twice. Now, in this neutral reading, what you will do is you will pick up your pen or pencil and you will start highlighting wherever you find there are dates. right? Or incidents, right? Just you have to just make a mark on the left side or right side of the moot proposition. And I would always suggest that instead of doing a digital a digital format reading, get a printout of that proposition and read it on paper, right? Pick up a pencil and start marking incident one. You could just write a Roman number 1. Second incident, Roman number 2. Like that, you can do for the whole proposition. So 2 readings, neutral readings, will make you make sure that all the incidents you have that have happened have been read by you, right? So you will do that marking on your moot propositions print itself, 1, 2, 3, for all the incidents that have happened, right? Now, after this is done, then you will go to the end, to the very end of the moot proposition. Even this one, if you go right at the end, there are 2 questions that have been put in paragraph 8. Paragraph 8 says, the sessions court rejected Siddharth's plea that the incident was a mere unfortunate accident and convicted him under section 307 of IPC for attempting to murder Rishika. The court also held that a person who enters into a relationship in the nature of marriage cannot be allowed to take the plea that he cannot be held liable under section 498A, as there was no valid marriage, thereby convicting him under 498A for cruelty over the course of their relationship. He was also sentenced to 10 years rigorous imprisonment. Aggrieved by the conviction, Siddharth appealed against the order of the Sessions Court before the Honorable High Court of Bombay. This appeal has 2 substantial issues. Now, always remember, in moot problems, they will not send the the case will not go to the lower courts. It will always go an appeal. And why an appeal, I will tell you. In moot problems, you send cases in appeal only, because in appeal only those cases will be accepted which have any question of laws that need to be decided, right? If there is a question relating to legal clarity, then only can a case go in appeal, right? If there is a question on facts, facts will not be readdressed in an appeal. Okay. So every time you pick up a moot problem, remember, I'm sorry. Okay. So there is a reason why this is done, because we want to train students to get acquainted with how to deal with law, right? To understand law better. So for example, if they are talking about 498A, which is cruelty. Just a second. Yeah. So if they're talking about 498A, that's a specific concept in criminal law, which is being dealt with. And that concept you have to read in full. And then see what are the possibilities of defending Siddharth or defending this woman Rishika. Either side, you will have to, if you're going in as a defendant lawyer, or you're going as a prosecution lawyer, or a lawyer on side of, let's say, this girl itself, Rishika. So you will be dealing with facts only with respect to all the reading on law that you have done, right? So first reading is your newspaper reading, second reading is neutral reading, third reading again is a neutral reading with markings. Fourth reading is your reading after you have read the last paragraph and you know what are the questions that have been raised. So there were 2 issues that were raised here. First was whether Siddharth can be held liable under section 498A of the IPC, right? 498A essentially deals with marital cruelty, right? Now the question is whether, because this is not a marriage, whether this will be considered, whether he can be held correctly liable for 498A, or should he be made liable under any other section in the IPC, right? So from one side, you are going to be dealing with this. The other side, you're going to be trying to prove that, yes, even if the relationship, the mens rea, the intention of the legislation is to make sure that cruelty does not happen in any relationship that looks like that of a marital, that has a marital status. And even if it is not a valid marriage, it cannot be considered as non-cruelty or not covered under 498A, just for the sake of it not being a just because of the sake of it not being a valid marriage, right? So you will be dealing with these issues. Now, let's say you keep this in mind and think that you're defending Siddharth, right? If you're defending Siddharth and you start reading these two issues, you will go back and do the fifth reading of the problem, where you will start highlighting the points that or facts which support Siddharth. Okay. Now, for example, I was reading 5 and I said that he came and he saw her holding a can of blue colored liquid. He immediately realized that it was kerosene, and he called her crazy and said that she had ruined all the fun in his life, and attempted to kill her by pouring kerosene on her, exclaiming that she was so firm on ending her life. Now you have to go back and read this line again, where he says that if she is so firm on ending her life, he would make it easier for her, right? Now, in this whole incident, it could have happened that Rishika herself was trying to attempt suicide at that time. He just walked upon her, got agitated, and the moment he got agitated, he was like, okay, let me help you and I'll pour this on you. Nobody lit the fire. Understand that none of them have lit the fire. Neither has Rishika lit the fire, nor has Siddharth lit the fire, right? So this is how you have to do a reading of the facts, guys. Fine. And this statement that she has given was given by Rishika after 1 week in the hospital, right? So these are facts that you will start highlighting in this fifth reading. You will start highlighting facts from Siddharth's side. Then you will do a reading from Rishika's side and you will start highlighting that part, right? Now, you will have to have 3 colored highlighters for this. One highlighter you will use to highlight facts that support Rishika. One highlighter should be used to highlight facts that support Siddharth. One highlighter will specifically be used just to mark out areas which are talking about law, right? Which means 6th para is talking about file of charges section 307 498A of IPC. You will highlight this, right? Then you will go on to highlight okay, so in this, because it's a criminal law problem, you do not have much of law being talked about. In many other propositions, what happens is there are too many legal points that are there. So you will use that highlighter to highlight all the legal points that are raised throughout the proposition. Okay, this is a standalone proposition which is relating to criminal law. So there are not many areas that you can highlight on legal points so much, because once you start reading theory about 498A and 307, then you will have more clarity on law and you will get a separate area to read on, right? So this is not a legal problem heavy thing. It just has 2 sections, and all the reading related to 2 sections, all the legal research related to those 2 sections is your burden as a Moot team, right? So this is how to read the fact sheet or the proposition, and this is, trust me, 70% of what you have to do in a moot court. Understand your moot proposition very clearly. After which we start to build upon how to draft your moot your moot memorial. There are 2 moot memorials that you have to make, one from the defendant side, one from the from the appellant side, right? So there will be one appellant memorial and one will be respondent memorial that you will create. Okay. Now, is there anybody who has a question till now and did not understand something or has a doubt? You can ask me.
Madam, excuse me, madam. Madam, actually here itself it is mentioned that there is no valid marriage.
Yes.
And then lower court itself said that 498A is not applicable. It's not held liable. Then why Siddharth is going for appeal for 498A? It's not required, no?
Now, so if you look at the recent debates on 498, this is a bit different from what we're talking. And I know that this question would be raised in your mind, Satish. You're correct in asking this question. So what happens is that there are certain sections that were being recently discussed in many cases where they were saying that they relate specifically to marriages that are valid marriages, right? Which means cruelty and maybe a lot of such things that were being discussed, specifically this section of 498A. Now, what happens is that you have legalized live-in relationships in this country, right? About 7 years ago, we have legalized live-in relationship in this country. And because of that reason, not 7, I'm sorry, it's 4 years ago, right? 4 years ago around, we legalized the concept of live-in relationships. And because we did that, what happened is that there are many relationships, there are many people who are living together, even though it's not valid marriage, but it has the same status of a marriage. The husband and wife or the guy and the girl have the same status as husband and wife to each other. Even for that matter, property, maintenance, everything, you have rampant judgments that are giving similar rights to couples who are staying in live-in relationships. Now, in such a state, there are questions that are raised in 498A like sections, and therefore these sections are to be discussed at length. And this is a proposition that is specifically made to make sure that you do more reading on what are the fallouts of doing this and what is the benefit of doing this, what are the pros and cons, understand it and do a debate around that legal issue, right, through this moot court. So this is essentially why. Does that answer your question?
Yeah, yes, madam.
Okay.
Yes,
Okay.
madam. Yes.
Is it a sentence period of 10 years for cruelty, ma'am? 498A?
I will have to check. I don't remember. Okay. I'm not a criminal lawyer.
It shows now, it shows 10 years
check.
of cruelty. So that
But I think it should be up to 10 years.
Up to 10 years.
Imprisonment up to 10 years. I think it's a.
Yes, madam. It's 10 years, up to 10 years.
Yes, either,
Okay.
yeah. So I think it should be up to 10 years because it's a serious crime.
Okay, ma'am.
Okay. So having said that, this is how you have to read a moot proposition. Now I'm just going to share with you one link which has a sample moot memorial. Okay. I have some moot memorials with me also. but because I do not have my pen drive as of now, so I can't share it with you. But feel free. Like once you are in campus and I am in campus starting September, you can very easily walk up to me and say that, ma'am, we need that sample. Please send it. Please give it. I will feel more than happy to help you out like that, right? So you can take those samples with from me. My ex-students who have gone to moot courts have prepared many of moot memorials. Some of the memorials that I had made also, they would be there. So it'll just help you, right? Now I'm just sending you a moot court memorial. Yes. Okay. Can I share it here as a document? Yes, I can share a file, right? So this is a respondent memorial I'm sharing with you. Please have a look. Look at the format. Just open it, and once you opened it, let me know, huh? Once you have opened this Moot memorial, just let me know. And how do you let me know? You let me know by raising a hand or writing a yes on the chat box. Sorry. I will just explain you the general format of a moot court memorial using this. Once you have opened it, just let me know, guys. Just write a yes once you have been able to access this. Okay, Vijay. Vijaya Lakshmi ji, thank you. Satish also says yes. Okay. 1 minute more for those who have not been able to access it yet. Dhaniti also, okay. Okay, guys. So now I will start. I think most of you would have been able to open this. Now, the first thing is that this format remains the same generally. You see a red page. The top page is a red page, right? And this page is red because this is a respondent memorial. So all the respondent memorials, first page would be a red page. All for petitioner memorials or for appeal side, on the prosecutor side, you will have a blue colored page. The first page has to be blue in color. So one will be a blue color, the opposite side is red in color, right? Now on the first page, you see there is a word, there's a box team code under which competition it is, that title is mentioned. Then you have the court in which the case is being filed. In our case, can anybody tell me where is this being filed? Where is the case being filed? You still have the fact sheet open, I hope.
That's what I mean, it's High Court.
Yes, High Court of
Bombay.
Yes, right? So it will be High Court of Bombay. It very clearly says that the aggrieved appealed against the order of Sessions Court before the Honorable High Court of Bombay. So you will write in the Honorable High Court of Bombay. And you will write appeal number, because in this, it's written writ petition, because this moot court memorial that is for whichever moot, there they were filing a writ petition. In the case that we are dealing with, you will write appeal number so and so oblique the year 2023, right? Now, after that, you will write under article. Because it was a writ petition, they have written under Article 32 of the Constitution of India. You will write section 498A of IPC, 307 of IPC, right? You will write this under you will basically, it's just a jurisdiction brief that is mentioned here. So you can write your appeal has been taken to court under which section. Okay. Then you will write the name of the appellant, which is in this case, I think on top it's written Siddharth Kapoor versus State of Maharashtra, right? If you look at the first page of your moot proposition, it says who against whom, right? So it's Siddharth Kapoor versus State of Maharashtra that you have to write there, right? Then you will write at the end memorial on behalf of whatever. If it's a respondent memorial, then respondent. If it's an appellant memorial, then you will write appellant. Okay. So this now, if you look at the table of contents, it is very important, guys, to have a list of abbreviations, which means any abbreviations you have used. Let's say you have, instead of writing your IPC, instead of writing Indian Penal Code, you have written IPC. You have to mention that in the list of abbreviations. I'm just going to ask you to go to the list of abbreviations once in the document that I've shared. So it says AIR, ANR, All India Reporter, because these are things that you, when you go down on the Moot, this memo, you will see cases being cited in various places, and at the end you will see AIR so and so number. That is the case number, and AIR is All India Reporter, where the case was published, from where you can go and fetch the details of that case. So everyone needs to know. Otherwise, what will happen is that anybody can say that X versus V, or X versus Y, X versus Z, L versus M, you know, like you can just make up cases. So you have to cite the cases every time you mention them in any of your memorials, or anywhere for that matter. Make this a thumb rule that your source should be very clear. Where have you picked up any information from? What makes a lawyer stand out from the crowd is the fact that he knows where his facts come from, right? You as a lawyer must know where is the source of the information. If you do not know the source of the information, you can never rely on it. Okay. You can only investigate such an information. You cannot rely on that information. Okay. Coming back to abbreviations. So this is a list of abbreviations that you can find on page 4. And this is a list that you will mention whatever abbreviations you're using in your memorial, you have to mention that. Then you have an index of authorities, very important. All the cases, authorities in terms of this memorials, what it means is that this case is the authority based on which I am saying that so-and-so judgment has to be given, right? So you will write cases and you will mention all the cases that you have referred in the index of authorities. Then you will write any secondary sources you have used, right? If there are any, let's say, sections that are there, which is primary, of course, primary source. So you will name the legislations, you will name the if there's any other section that you feel is relevant, you will mention that, right? So all the sections you will mention, all the laws that you are referring to, you will mention under provisions, right? In this memorial, it says constitutional provisions because they're specifically dealing with that. You can just mention legislations or provisions, right? Legislative provisions or provisions. You can just write that and mention all the provisions that you're dealing with, all the sections that you're dealing with, all the laws that you're dealing with, right? Then you have books. So if you're citing a book or any commentary from a book, if you have gone to the library, you picked up a book and you saw, okay, so-and-so has said so-and-so about 498A. I think this is relevant to my case, I will mention it. Or let's say you go to Manusmriti also, and you feel that, okay, there is something relevant written in Manusmriti that could help my case, you pick up those lines, you mention them, but then in books you will mention Manusmriti. Is this clear?
Yes, ma'am.
So any books, any cases, any laws, any other relevant articles, any journals, any newspaper articles, anything you are referring to, everything has to be mentioned in your list of authorities, right? Under different subheads, of course. Okay. Now you have a statement of jurisdiction, which is one of the most important things and the first things that in oral rounds, a judge would open and see that whether you have the jurisdiction correct or not, right? So statement of jurisdiction is nothing but under what law have you come to the court? So your law has to be very clear that if, let's say, in constitution, generally what happens is that there is a lot of glitch on under what law are you coming in, whether you're coming under appeal, if you're coming in SLP, special leave petition, what also jurisdiction becomes a very important thing when it comes to constitutional law issue, moot courts. Otherwise, also it becomes an issue in many areas, like let's say arbitration, moots, you'll see a lot of jurisdiction issues that are there, or for that matter, what basically jurisdiction deals with this, that if it's 498A, who gave you the right to come to this court saying that 498A appeal should come to Bombay High Court? So there would be law that would say that, okay, matters and appeal must go to so and so court. What law says that? It could be code of criminal procedure that says it. There would be different sections. So all of that reading, once you do, you have to mention that statement of jurisdiction in your moot memorial itself, right? Now, statement of facts, very interesting area. Statement of facts, do you need to, will you just copy paste all the moot proposition in the statement of facts? Guys, I'm asking you something.
Yes, madam. What we do?
Will you cut, copy, paste the moot proposition in the statement of facts in your memorial?
Okay, ma'am.
No. So the answer is no. You will mention statement of facts. Statement of facts is all the facts that are relevant to you as a respondent or as a petitioner, right? Whatever side you are defending, whatever side you are on, if you're a defense counsel or you're a appeals counsel or an appellant's counsel, you have to, or a prosecution, basically, whoever, whatever shoes you are in, or whatever memorial you are making on behalf of whomever. So for example, the sample memorial I've given you is for respondent. So the statement of facts will be facts mentioned, only those facts which support the respondent you would have mentioned. Is this clear?
Yes, madam. Actually, this is like, so highlighting facts, you are told no highlighting facts from Siddharth side.
Yes, yes.
And those facts has to be mentioned here.
Yes, yes. So if you are Siddharth's counsel, you will be writing facts that are relevant to Siddharth being defending, being evicted of his crimes, right? Being so that because you are going in appeal to get him out of the prison, right? So you have to write facts that support his side, right?
Okay.
So you cannot copy paste all the proposition. You have to write down 10 facts. And remember, I'm giving you this thumb rule again, another thumb rule, that do not go beyond 10 points in a fact sheet. Statement of facts, you should have just 10 relevant facts to your case. And that is just exactly what your judges, when you go to the moot oral rounds, is going to ask you that what are you contending? Tell me 5 facts that are relevant to your case, or 10 facts that are relevant to your case. At that time, if you're able to brief them correctly, you will have an edge over the other team. Okay, so this is statement of facts. Now, issues for consideration, which means what are the issues that have been raised. So tell me, what are the issues in this case that have been raised?
Yes, 2 issues, madam. One is,
Yes. One is whether the 2 issues that have been mentioned on the last page, right?
Yes, ma'am.
Okay. But this, but is it important that you only stick to those 2 issues?
no, madam, as you said, that so because recently 4 years back, you told, no, so the living relationship also has been accepted by the courts. So then other section has to be checked. Whether,
Right. Okay, Satish. Perfect. So guys, it is not important that only the 2 issues that they have mentioned in the proposition are the issues that you'll deal with. You can actually go on and add issues if you feel that they do not come under the umbrella of those 2 issues, or this is a 3rd issue or a 4th issue that you think is relevant to the case to prove your side of the story and has to be added, right? Do not make up facts. I'm not asking you to draw facts on your own or have any assumptions. I'm just asking you that if there is any issue that does not fall within the ambit of the 2 issues or 3 issues that have already been mentioned in your proposition, then you can add a 3rd or a 4th issue or an additional issue which can deal with that problem specifically, right? So there is no bar on doing that. But do not go on adding like 8 issues altogether, 10 issues. It just creates a lot of problem, and most of the time what happens is that all those issues that you will create separately would generally come under the umbrella of the issues that have been already mentioned. But sometimes just in tricky moot propositions, there would be issues that would be subdued or that would be hidden and they are not mentioned very clearly. So you can make that as an issue so that it supports your case, and only if it supports your case, right? Do not make an issue when you know that Siddharth will not be benefited by having another issue to deal with. That as Siddharth's counsel, it will be a hassle for you to prove it, right? Now, after this, okay, so you will mention the issues and then you will have a summary of arguments and arguments advanced. These are the 2 titles that are left in a memorial that you have to deal with. Okay, first thing is summary of arguments. So you will not first write the summary ideally. As a process, what you do is that you will deal with each of the issues, and you to answer these issues. Let's say, for example, the first issue is whether in the memorial that I've given you, it says whether the writ petition is maintainable in the present case in the Supreme Court of India. So, Cardia. So this specific issue is being answered by this advanced arguments. If you go and it says the writ petition in the present case is not maintainable because there is no violation of fundamental rights. An alternate remedy is available. Trisco is not the state, therefore can make reasonable restrictions as per the religious rights, right? So the advanced arguments are basically an answer to each of the issues that are mentioned. And instead of writing, so I don't know, there is some glitch in this specific Moot memorial sample. Do not go by this. You will not write whether the writ petition is maintainable. You will write that. When you're writing arguments advanced, you will write that the writ petition is maintainable in the present case in the Supreme Court of Cardiff, right? So the
can you explain me writ in
writ right now? Writ is a very big concept of
no,
constitution.
ma'am, for basic, just to understand, ma'am.
Okay,
Writ is
okay.
already given order, ma'am, or it is a new? I cannot understand.
No. Okay. I will tell you what writ is. Just I'll give. I'm not a constitutional law professor, but I will tell you what writ is. So writ is a basic thing that you file for getting an immediate relief from Supreme Court or the High Court, right?
Okay.
When there's a constitutional case, constitution's case, or if there is any breach of your fundamental rights, the basic rule is that if your fundamental right is breached, there are fundamental rights mentioned in your constitution. And in the constitution, those fundamental rights have been mentioned to protect your interests as the citizen of this country, right? So if by chance there is some right that is breached, you feel that, let's say you want to give vote on election day, but somehow due to some reason you cannot vote. It is your fundamental right to vote, right? Right to vote is a fundamental right under the constitution. And because you could not vote because of some action of the state, you can go and file a case against Shivaranjini. I think, yeah, your mic was open. Right. So you can go and file a case against whoever has stopped you from having that fundamental right in the High Court or the Supreme Court as a writ. Okay. Now, there are different kinds of writs that are there. Some of the famous ones are habeas corpus, mandamus, certiorari, and they mean different things. So if I start explaining you it right now, it will be like 5 classes lecture. Just
enough. No, can understand. No, understand.
If you breach a fundamental right, you can file a written appeal, okay, to Supreme Court and High Court. Okay. But you'll know more about it when you read constitutional law. Trust me, it's a very interesting concept and a very important one at that. So many of the big lawyers that are there, they are just earning based on writ petitions that are being made to Supreme Court and High Court, right? Okay, coming back to the memorial. So this is a problem in this memorial sample that I've given you, where it is written advanced arguments. Do remember that you will write that the writ petition, you will not write it in question format in advanced arguments. Advanced arguments are never in question format. They're a statement, right? Your argument cannot be a question in itself. If you do that, the judge is going to laugh at you. I don't know how this sample is made, but the sample is incorrectly mentioning that whoever did it must have had a bad time in the court with the judges. So you cannot have a question as an argument in the court. You have to make a statement, and that statement has to start not with whether, what, how, or any other questioning words. It will start with that, right? You will say that, T-H-A-T, that the writ petition is maintainable, or that Siddharth is not liable for 498 cruelty, right? So that's how you start your argument. Issues are to be in question form. Arguments are supposed to be in statements, right?
Okay.
And this is true for any petitions you will file in the court also. You cannot go on to the court and say that my argument is whether this is happening. The judge will say, when you don't know, how will I know? Right? So you have to tell them as a statement. Okay, so this is, and after you've written all the advanced arguments, then a summary of each of those arguments you have to write in summary of arguments. But when it comes to the memorial, you will first have the title of summary of arguments, and then you will have advanced arguments. It's just easier for the judge to refer. So while they are referring to your memorial, they will see the summary first and then go to each of your advanced arguments and see it, right? So for that reason, you will first have the summary mentioned and then you will have advanced arguments. But as a team, when you're preparing, you will first form the arguments and then write a summary of it, right? Okay, having said that, another important point is your last, I think in the end, you will have references and prayer. Yes, prayer is very important. Prayer for relief is something that the judge is going to ask you, okay, why are you coming to this court? What is your prayer? At that time, prayer has a standard format and language, and you have to mention this. Wherefore, in the light of the issues raised, arguments advanced, authorities cited, reasons given, the honorable court may be pleased to. After that, you will write what you want from the court. Let's say you want hold that so-and-so is not, that so-and-so marriage is not valid. 498A will not be applicable to to marriages which are not valid. Siddharth is not liable for so-and-so, right? So you will basically, you will be mentioning what you want the court to do with your petition. Why have you gone to the court? That you have to mention in the prayer, right? Always remember, when you say the prayer, all the three participants in the team have to be standing from their chairs, and then saying and then one person will be saying the prayer. The speaker can be saying the prayer, but the rest of the team has to be on foot, which means they have to be standing. They cannot be sitting while their co-counsel is praying to the Lordship, right? So this is an ethic in the moot court. Okay. And at the end, there is another template language that has to be added, and any other relief that the honorable court may be pleased to grant in the interest of justice, equity, and good conscience, all of which is respectfully submitted, right? And then you'll mention this counsel for the respondent. There will be a space for signature, right? Now, what does justice, equity, and good conscience mean is your homework to do. You have to find out what these three words mean, because unless you know, many a times judges will catch hold of you and say that, why are you saying this? Why is your prayer saying that justice, equity, and good conscience? What does it mean? And you don't know this template, what the template language means, you're caught off guard, right? And they could actually laugh you off. So you don't want to be caught in that. So any template language that is there, just go and do a general reading on what does that mean. Why is the template language being used? Who started with this? Where is it coming from, right? So that's a lot of knowledge actually in history, if you start reading like that. Increase your inquisitive quotient. That is the last thing I want to suggest. We have had two very, very nice sessions on mooting, and trust me, this will prepare you for the court like nothing else will. Your theory fundamentals is each of your faculty's responsibility when they're teaching you in the classroom, and then out of the classroom, it's your responsibility to read that subject. But that is theory. But when you go to the court, how much prepared you are will depend on many of those things that I've taught you in the last 2 days and what you're going to do in the moot courts over a period of your degree. So just remember that your inquisitive quotient has to be very high, right? Which means that question, increase the frequency of questions that you ask. Ask kyun, kya, aisa kyun, why Why is this written? How is this written? What does it mean, right? You have to keep on asking these questions. And when you go through now, just make it a habit, highlight everywhere. Whatever law, whatever material is given to you, whatever you can't understand, just draw a line under it and make sure that you go and Google it. I'm just asking you to Google it. The number of things that you learn with just doing this, you will know in 1 month's time, you will have such immense knowledge. Another thing that you'll develop is the basic attitude of asking questions. And the moment you develop that, you will never not know. Your knowledge will increase and you will not believe unless you have actual sources in mind. And you will know how to synthesize information. So nobody can actually fool you if you're able to question, right? If somebody comes and says to you that, okay, hibiscus flower is good for health, you're not going to just believe them, but you're going to ask them that, why are you saying this? Why hibiscus only? Why not rose? Why not any other flower? And what do you mean hibiscus is good for health? In what terms? What qualities does it have? So that general attitude of questioning and knowing an answer will help you develop knowledge, right? Okay, so this brings me to the end of this session. And if there are any questions, please feel free to write to me over email or reach out to me on my contact number. I'm just mentioning my email address, which is my official email address. Please feel free to write to me an email about either you want to say something about the sessions, you want to ask any questions, or you want to know more about mooting. Just feel free to write to me, right? And expect a response in, give me like 2-3 days time to respond. I will generally be sending emails in the morning hours. So please have a look at your emails in the morning, and I'm sure you're going to find my responses. 2-3 days you will need for me to respond to those emails. But actually feel free to write to me. If you need an appointment to meet also, you can just mention that. And if it's an online meeting that you want, please mention where you want it, how you want it, which means that which medium. I would prefer Google Meets. Do let me know if that works out for you. If you want a calling is for any urgent purposes that is there. So you can reach out to me and ask me for my number over email and call me if there is something urgent. Otherwise, we can always discuss things over email. And once I am in campus, you can walk up to me and reach out during my work hours when I'm in office. I would feel very happy to interact with each one of you. And welcome to VMLS. Glad to make your acquaintance. I am looking forward to meeting you all in September. Okay, thank you so much. I hope you liked this session. Please write to me over email on this. And host, we can now close this session if there's nothing else that the students have to say to me. Thank you, Satish. Thank you for being so active in the class. Thank you. Thank you, everyone. Host, can we close this session now? I don't know, our host seems not around. Okay, guys, you can exit the session if you feel like it. Thank you.